Hi, I'm Susan Im of ImLaw. I have practiced exclusively immigration law for over 15 years. Today's topic is family-based green cards, obtaining permanent residency through family members. U.S. citizens may sponsor certain categories of relatives, and this category includes spouses, parents of U.S. citizens, dependent children under the age of 21 of U.S. citizens, and siblings of U.S. citizens, whether married, unmarried, under the age of 21, over the age of 21, doesn't matter. The U.S. citizen petitioner must, however, be at least 21 years old to sponsor these categories of relatives. Lawful permanent residents, otherwise known as green card holders, may sponsor spouses, as well as their unmarried children, whether under the age of 21 or over the age of 21. They may not sponsor married children, and they also may not sponsor parents. Depending on the status of the U.S. citizen petitioner and the family relationship, visas may be considered immediately available, or there may be a substantial multiple-year wait. For immediate relatives, and immediate relatives include spouses of a U.S. citizen, unmarried dependent children under the age of 21 of a U.S. citizen, and parents of a U.S. citizen petitioner. Remember, the U.S. citizen petitioner must be 21 years old, so a 5-year-old U.S. citizen child cannot petition for a parent. There is no backlog of visas, which is wonderful because Congress created decades ago numerical limits on most of the family-based immigration categories. So we're not hindered by backlogs in the immediate relative category. However, one does need to wait out the normal processing times for an immediate relative immigrant petition process. Following the immediate relatives, which are really at the top of the immigration family-based hierarchy, are the preference relative categories, and they are known as first preference, second preference, third preference, and fourth preference. First preference is comprised of unmarried children of U.S. citizens who are now 21 years of age or older. The second preference category relates to relatives of permanent residents, green card holders. That's second preference. A category are the spouses and children under the age of 21 of permanent residents. And the second preference B category is comprised of unmarried sons and daughters over the age of 21. The third family-based preference category is comprised of married children of U.S. citizens, regardless of age, children that have now married. And the fourth preference category, the lowest rung of the family-based hierarchy, are siblings, brothers and sisters of U.S. citizens, and again, the U.S. citizen must be at least 21 years old in each of these cases. What is the procedure to kick off a family-based immigrant visa or green card case? Well, if the foreign national is located outside the United States, it always starts with an I-130 immigrant petition filing. The I-130 requires certain supporting documents to be included, and they are the foreign national's birth certificate with any certified English translations. By the way, the USCIS requires certified English translations for any document that is not in English. We need to include proof of the U.S. citizen or the permanent resident status, whether that's a naturalization certificate, U.S. passport, copy of the green card. And you also need to include proof of any termination of prior marriages. For instance, if the foreign national that is immigrating is now divorced, you want to put in a copy of that divorce certificate, annulment certificate, or death certificate if the prior spouse has become deceased. For immediate relatives, it is very important to keep in mind that the U.S. citizen petitioner must file a separate I-130 immigrant visa package for each dependent qualifying child. And this is, again, a very strange occurrence in immigration law. For the family-based first through fourth preference categories, any dependent children of the principal alien is just simply included in the same I-130 done for the principal alien. Not the case for the immediate relative category, where you've got a shorter process than the family-based preference categories, but you do have to spend a little more money and take a little more time, file and prepare a separate I-130 package for each of the qualifying children of that dependent spouse, for instance. So where do we look for information to determine if there is a backlog in your particular family-based category? Well, there's something called the Visa Bulletin, and it's available at the U.S. Department of State's website, travel.state.gov. So travel.state.gov. You can see with each month there is a clear listing of the family-based categories 1st through 4th, and you will see the priority date that the government is working on at that time, meaning the priority date is established by the filing of an immigrant petition, an I-130 immigrant petition with USCIS. The filing of an I-130 establishes one's priority date or place in line for purposes of the family-based backlogs. And if you look at the Visa Bulletin each month, you will see what priority dates the government is working on at this time. And then you can add up how many more years it will take before the government gets to your particular relative's priority date. And you can try to estimate then the remaining amount of time that you need to wait in order to be reunited with that family member. Keep in mind that in addition to the numerical limits that Congress set on each of those 4 family preference categories, there are additional quotas imposed on persons born in China, India, Mexico, and the Philippines. And these visa quotas are significant. In some cases, it results in an over 20-year wait for certain family members to be reunited. So we talked about the USCIS as being the first agency where the I-130 immigrant petition is filed. Following an I-130 approval, the USCIS sends notice of the approval to the U.S. citizen petitioner, and the original petition and file gets sent to an agency known as the National Visa Center. The National Visa Center will conduct preliminary processing of the case, will accept fees that are required for the second stage. There is a immigrant visa processing fee, as well as something called the affidavit of support fee for each beneficiary listed on the I-130 petition. Now, where the case does not have a priority date that is available, the National Visa Center will notify the foreign national beneficiary and the U.S. citizen petitioner of its receipt of the case from USCIS, but will also include a note that the priority date is not yet current. The National Visa Center is supposed to notify both the beneficiary and the U.S. citizen petitioner once the priority date does become current again and processing can resume. So where the priority date is current for a case, we talked about the National Visa Center accepting fees for the immigrant visa application as well as the affidavit of support fees. There are also certain documents that the National Visa Center will request of the foreign national relative, and they will typically include police certificates from certain countries where the foreign national has resided, will include original or certified copies of the foreign national's birth certificate, divorce judgments, annulments, death certificates for any prior marriages, if it's a marriage-based case. It will also include a request for certain supporting documents for the U.S. citizen petitioner's affidavit of support. And the affidavit of support is essentially a document where the U.S. citizen petitioner, or maybe a joint sponsor if the U.S. citizen petitioner is unable to do so on his or her own, is attesting to being able to keep that foreign national relative or relatives at least 125% above poverty level. The National Visa Center will request certain documents of the U.S. citizen petitioner for the affidavit of support, or if a joint sponsor is required, certain documents of that joint sponsor, and typically that will include proof of employment as well as tax returns. Once the National Visa Center completes its preliminary processing of the case, typically the immigrant visa case will be sent to the U.S. Embassy or consulate in the foreign national's country and scheduled for their immigrant visa or green card interviews. In a case where the priority date is current and the foreign national happens to be physically present in the United States and is eligible for what's known as adjustment of status, and being eligible means having to prove that you were lawfully admitted to the United States following inspection by an immigration officer, and you're otherwise eligible to apply for adjustment of status, meaning you're not inadmissible on a criminal or security, health-related ground, or affidavit of support-related ground, then that foreign national may actually file the I-485 adjustment of status, the final stage of a green card process, concurrently with the I-130 immigrant petition. And this can be filed at the USCIS National Benefits Center. With the adjustment of status filing, the foreign national may be eligible to file for employment authorization, as well as the ability to travel abroad while the green card application is pending. And with the travel document, it's critical to look at the admissibility issues, the background of the foreign national, because the foreign national may be subject to 3-year and 10-year bars depending on their background. But the employment authorization and the travel authorization document, if eligible, are filed concurrently with that adjustment of status filing. Well, that does it for family-based immigration for today. My name is Susan Im of ImLaw. For more information, please visit imlaw.biz.